Okay, so for those of you who don't know me, I'm sure many of you do, so bear with me if you do. I am the best-selling author of GDPR for Dummies. It now has 81 five-star reviews, which I'm absolutely thrilled with. If you've not seen it yet, this is the book. If you haven't bought it yet, then do go and buy it. It's still on a little bit of an offer on Amazon, and do tell all your pals about it too. I've had feedback from business owners, but also interestingly DPOs and data protection professionals who say it is their Bible. The aim in writing it was to make a really comprehensive but very simple guide, implementable guide to the GDPR. And on reading the reviews, I think I've achieved that. So if you haven't yet checked out the book, then do go and have a look at that. And also, I think that a lot of people, if you're new to this area, you wonder where to go next, because you might think, well, okay, I know all of this now, but where's the next step? I haven't got money to go and pay lawyers to do this for me. Where's the next step? So that's a really good starting point. And also for those of you who haven't already got all of the legal documents that you need, then I'm still selling my template pack for just £197. It comes with 12 months of free updates and support with that. And you can just go to suzannedibble.com/GDPR pack, and that will provide you with all of the documents that you'll need to be compliant. And actually the book kind of sits alongside that pack and talks you through the documents. So if you have both of those resources, you will absolutely be able to implement this in your own business. I'm founder of the largest social media group on GDPR for Online Entrepreneurs Facebook group, which many of you I know are in, still going strong. I'm Richard Branson's ex-lawyer. Yes, I got to hang out with Richard, go to parties at his home in near Notting Hill. I went for dinner with just him and a couple of other people, and yeah, had heard all his stories, went nightclubbing with him on the King's Road. Really impressive individual. And little did I know at the time that most entrepreneurs would give their right arm to go for dinner with Richard Branson. I don't think I realised at the time what a big deal it was, but I learnt lots from him. And I'm still a little bit sad that when he offered me, because I was on secondment with them, I was their very first secondee from the city law firm I was working at, and he pretty much begged me to stay, and I said no, somewhat foolishly, I now think. So I often wondered how life might have been different had I accepted that job. Maybe I wouldn't be here now. I wouldn't have created the Small Business Legal Academy, and I wouldn't have helped all of the many tens of thousands of small business owners that I have. I led the £1 billion digital switchover project for ITV. So if you know when the TV went from analog to digital, I negotiated all of the contracts for that huge project, ITV's biggest ever commercial project. I was a board member of a very large company by the time I was 30. And as a result of that, was included twice in the who's who of Britain's business elite. And you get this big, thick book about sort of, I don't know, 10 centimetres thick, maybe more. So clearly it wasn't just me. There were many people listed in the who's who of Britain's business elite. But if you ever find yourself looking at one of those, if you go to Suzanne Dibble, you'll see that I was listed in there twice. All good for the CV. Anyway, enough about me. So, and really they were just, I mean, really my passion now, as I'm sure you know, oops, the slides are going haywire, is to help small business owners. And that's really what I've dedicated the last 10 years of my life in doing. The reason why I set up the Facebook group, the reason why I created the Small Business Legal Academy, the reason why I created my GDPR pack is because I feel that small businesses should not be limited in accessing quality legal services just because they don't have a large legal budget. And that is what I'm all about. Anyway, enough. So into the nitty-gritty of it. So firstly, how does privacy law and cookie law work together? And I often find that this is an area that people struggle with. So we're going to look at this right up front. Now, the GDPR governs the processing of all personal data, and that includes cookies and other online identifiers. But then sitting alongside that, you've got the e-privacy directive, which is implemented in the UK as the Privacy and Electronic Communications Regulations, often called PECR. I call it PECR, but there you go. And that governs the use of cookies and also sending unsolicited direct marketing, emails, texts, fax, and automated calling. So the two laws work alongside each other. Now, GDPR is not all about consent. A lot of people think it is, but it's not. There's 6 lawful grounds of processing, and consent is just one of them. However, the e-privacy directive and PECR, as we've implemented it in the UK, is about consent, certainly where cookies are concerned, and indeed for sending unsolicited email marketing, etc. It's about information provision, and it's about consent. So I often get questions about, say, analytics cookies, and people will be saying to me, but this is anonymous data, and surely, you know, we don't, because if you know anything about GDPR, you'll know that if data is truly anonymized, then the GDPR doesn't apply to that. Now, if it is possible to have analytics data that are truly anonymized, that really doesn't matter, because e-privacy governs the use of cookies, and that says that for any non-essential cookies, and analytics are classed as non-essential cookies, you require consent. And the GDPR says that if consent is required for e-privacy purposes, consent is also required under the GDPR. So there's a number of areas, and quite common areas in marketing, and particularly online marketing, where the two work in tandem, and you can't just look at one or the other. Now, in terms of the territorial scope of this, if you're new to this area and you're trying to work out whether you should be watching the rest of this webinar or not, the GDPR applies to all organisations that process personal data of data subjects within the EU. And that obviously includes organisations that are established outside of the EU. So if you're based in the US or Canada or South Africa or Australia or anywhere outside of the EU, then to the extent that you are processing the personal data of individuals within the EU, the GDPR applies to you. Now, on the other hand, with e-privacy, the plan was that amendments to the e-privacy directive would be made at the same time as the GDPR, so that they would come in force at the same time. And the plan was to extend the territorial scope of the e-privacy directive to be the same as for the GDPR. Now, that didn't happen, mainly because of the heavy lobbying by the advertising industry, and it is still being negotiated. The presidency it rotates on a 6-month basis, and there's been a number of presidencies now that just haven't been able to make any progress. And the latest from the now, who is in at the moment? I've lost track. And it's not telling me from this. Anyway, this is the latest, which basically says we've not been able to make any progress. Although, oh yes, sorry, it's the Croatian presidency at the moment, and it's the incoming German presidency this month. So in this paper they've basically blamed the coronavirus. So we'll give them that one. But many presidencies before this haven't really been able to progress the amendments to the e-privacy directive, as I say, because of the heavy lobbying by the advertising industry, because what they're trying to do is really end the under-the-radar surveillance that is going on in the ad tech industry. And the ad tech industry don't like that. So they've been lobbying super heavily, and who knows where that will end up. So for those of you who are established outside of the EU, then do bear in mind that when I'm talking about the e-privacy directive, it doesn't apply to you, well, it possibly doesn't apply to you now, unless you have equipment that serves cookies in the EU, in which case it might apply to you now. But do think that in time, who knows when, hopefully in the next year or so, it will apply to you. I say hopefully, not that it will be a good thing for you necessarily, but it will be good to end this ongoing discussion about where the amendments to the privacy regulations are going to end up. So just wanted to deal with that up front, because I do find that this is a real, well, it's an area that people don't really understand how these regulations work together. And do bear in mind that, so the reason that the GDPR was implemented as a regulation was to try and harmonise data protection laws across Europe. The e-privacy directive, however, it's a directive, and what that means is that national states, EU member states, have to implement laws to make that law, and they have a discretion as to how they do that. So for e-privacy matters, each state is slightly different. Okay, so if you are doing email marketing in a number of different EU jurisdictions, then you will need to look at the exact law in each of those jurisdictions, particularly where it comes to things like the soft opt-in, because different member states will have different approaches to that. Now, there is a table or certainly a link to a table in my book in the marketing section. So if you've got the book, have a look at that. There is a very useful table as to how it differs across Europe. Okay, so what might you be thinking if you're new to this? You might be thinking, well, why bother complying anyway? You might be thinking, how is this even relevant to me? You might be thinking, well, everyone else is ignoring it. My competitors aren't bothering, so why on earth should I? You might be thinking, well, I'd like to comply, but I've really not got the time. I'm trying to keep my business alive during this coronavirus crisis. I haven't got time to look into all this complex legal stuff. You might be thinking, well, I haven't got the time to do it myself, and I certainly haven't got the money to pay lawyers to look into it for me. You might be thinking, I'm too small an organisation to be fined, so why do I even need to bother? And even if I do get a fine, it's only going to be small, so I'd rather take a risk. And you might be thinking, what about Brexit? You might be thinking, most of my website visitors are in the UK, so surely this won't be an issue after Brexit. Well, of course, it will be an issue after Brexit, and I'm going to tell you more about that later. And, maybe those of you who are on live, maybe you're here because this doesn't apply to you. You've embraced GDPR, and that's why you're here. For those of you who might discover this webinar at a later date, then I'm sure that you've thought some of these thoughts. I'm sure that even if you're complying to a certain extent, you might be thinking, well, I'm not going to take those extra steps because you've done a risk analysis. But here's why you should care, because your website users care. And Axiom surveyed over 10,000 people in 10 countries and asked them this question. On a scale of 1 to 10, where 1 is not at all concerned and 10 is very concerned, how do you rate your level of concern about the issue of online privacy? And this shows the percentage who answer 7 to 10, i.e. very concerned. So as you can see, the country that had the most concerned people there was the USA, with a whopping 82% of people being very concerned about the issue of online privacy. Now, maybe unsurprisingly, the USA has one of the most lax data protection regimes. But as you can see, the other countries there, Spain, 81%, Canada, 77%, Australia, 75%, extremely high numbers. Even the lowest percentage out of those 10 countries surveyed was at 65% in the Netherlands. And we're seeing across the board that trust, where personal data is concerned, is becoming increasingly important. In addition, complaints are on the up, so maybe you should care. The ICO annual report, for those of you who are new to this area, the ICO is the Information Commissioner's Office, which is the regulator for data protection in the UK. Their last annual report showed that complaints had doubled. And this is really because this was in the year after the GDPR came into force. And the reason for this is that data subjects are just much more savvy about their data protection rights. The ICO and other regulatory authorities across Europe did public-facing awareness campaigns. GDPR, when it came in, was very much in the media, mainly because of the headline-hitting fines. But data subjects are much more savvy. And I'm sure, you know, you've been there, we're all consumers, you've been there yourself. If you go onto a website and you're now aware of what they should be doing for data protection matters, are you more likely to trust them or more likely to not trust them if they're doing things properly or not properly? I know certainly that when I go onto websites and they don't have the right consent for cookies, or they don't have an up-to-date privacy notice, or they're not giving me the right opt-outs, you know, my trust in that organization has gone, because my personal data is very important to me. And if they're not respecting that, then it really shows me that they don't respect me as a customer. I'll take my business elsewhere. So not only are complaints up, but the exercise of data protection rights are also on the up. And this is a big reason to care. The ICO annual report showed that 64% of organisations in the UK saw a noticeable increase in the exercise of data protection rights. So maybe that's subject access requests, it's the right to be forgotten, maybe it's the right of data portability, whatever it is. Data subjects, again, they're more savvy about these rights. It's more of an issue for them than it's ever been, and they are more prepared to exercise these rights. Now, this isn't 64% of complaints to organisations. This is 64% of organisations seeing an increase where, you know, they've come to them and actually, you know, it's not just a complaint, but it's actually understanding the right and asking for the exercise of that right. And this is why it's so important that we train our staff to recognise the exercise of data protection rights, because it doesn't have to be in a formal, there's no form that it needs to take. It doesn't need to be a letter to the registered office. It can be as simple as a tweet or other social media to say, how did you get my data? And that is a subject access request. And if you don't respond properly, if you don't respond in the right time period, then chances are that that data subject will take that to the next level and will put in a complaint to the ICO or whatever regulatory authority it is in Europe. And then you're facing a regulatory investigation, which is really where no small business wants to be. And in addition, data breaches are on the up. So in 2020, there was a 12.6% increase in reported data breaches. And so obviously we don't know what the increase would be for non-reported data breaches. Hopefully organisations are getting better at understanding when they need to report, but still a marked increase in the number of data breaches. So hackers are as persistent as ever. Hackers are becoming more sophisticated. And also it's worth remembering that about 80% of data breaches are due to human error. So whether that is employees leaving sensitive files on trains, whether it's unprotected devices being lost, whether it's sending information to the wrong people by email. So training is an absolute essential. And if you trained your staff when GDPR came into force and think that you've ticked the box, please have a rethink about that. This should be ongoing training. And certainly for new employees, that should be part of the induction process. So I'm sure we all know that the fines under the GDPR increased significantly. This was in all of the headlines at the time. And what we're going to do is look at how actually these have been put into practice. So just as a reminder, the maximum fine pre-GDPR was €500,000, and the maximum fine post-GDPR is 20 million euros, or 4% of your worldwide annual turnover for the preceding financial year, whichever is the higher. Now, obviously, if you're a Google or an Amazon, that is going to be significantly more potentially than 20 million euros. And indeed, we saw the fine from the French Data Protection Authority to Google of 50 million euros last year. And who knows what Facebook are going to be fined, because they're being investigated by just about every European regulator. So we'll have to see where Facebook ends up. But in practice, fines are on the up as well. So obviously there's the potential to bring these increased fines, but fines are on the up. And this chart here shows the, well, this is up to the 17th of January of this year, so it's a little bit out of date now. But it shows the fines that have been introduced across Europe. And what's not included in there actually is the 2 large fines that the UK ICO levied on British Airways and Marriott, because they're being disputed. So that totaled about 282 million. So that would certainly put the UK up in that ranking. But what we're seeing certainly is that supervisory authorities have had to take time to get up to speed with the new regime. They've had to certainly employ lots more people in the UK. The ICO's numbers increased significantly, and it takes time to investigate and to build a case to justify a higher fine. Now, rightly or wrongly, the European regulatory authorities are focusing on the big tech companies, and we're seeing, well, we're not seeing as many as perhaps some of us thought of the lower fines coming through. But we do certainly expect to see many more multi-million euro fines in the coming year. And certainly I think even on the smaller scale too, we will see a lot more. But fines aren't the only potential exposure for organisations that are in breach of the GDPR. Supervisory authorities enjoy a wide range of powers to impose other sanctions, not least the ability to publicly name and shame your organisation, which for me, you know, even if I weren't to get a fine, being publicly named, well, obviously for me it would be terrible. I have to be seen to be whiter than white. But for any organisation that cares about their reputation, that is certainly something to be considered very, very strongly, because you don't want to be known as the organisation that was fined X amount, or even not fined, but was, you know, there was some other sanction like being told to stop processing your data. Because people write about this and it gets known and it gets shared within business communities. And perhaps most worrying is the risk of follow-on compensation claims, including group litigation. I don't know if you saw them, certainly I seem to be bombarded by them, but adverts on Facebook from law firms who were establishing a group action against British Airways when they suffered their data breach last year. I was served probably 3 or 4 of those adverts a day. So law firms are really being keen on advertising for those types of group actions. And again, you really don't want to be on the receiving end of that. So that's a little walkthrough of why we all should be still very conscious of our data protection obligations. And I'll do a wrap up at the end as to why it really is critical for the success of your business. Now, you might get away with it for a certain amount of time. The problem is we don't know what's around the corner. You don't know whether that one person that, you know, has noticed that you've not done something in a completely compliant way, whether that person is going to report you or not to a regulatory authority. You don't know whether a competitor is going to notice that you've done something and will report you. You just don't know what's in front of you. So certainly in my view, it's better to err on the side of caution, be compliant, not just for the sake of compliance, the sake of compliance in itself, but to treat your personal data of your data subjects in a way in which you would want your own personal data to be treated. So let's have a little reminder as to what is personal data. I know the vast majority of people watching this will want to do the right thing, and that the trick is in the actual implementation, because let's face it, it's a complex area. So what I hope to do in my book and in my regular webinars that I do with my GDPR pack, with my Facebook group, is to make it easier for you to actually implement compliance within your business. So what is personal data? Pretty much any information that identifies or is capable of identifying an individual. So it's very broad. And it includes cookies, as we've already seen, cookies and other online identifiers. It includes photographs. which can be personal data, but it might depend on the purpose as to whether it actually comprises personal data or not. Certainly the guidance notes from the ICO say that if you have, say, a photograph of a crowd where individuals' faces are, they're not blurred out, you can see those individuals, but the purpose of the photo is to show that a sporting event was very well attended, then that would not be personal data. If, however, you had a picture of that same crowd scene on somebody's personnel file because they'd called in sick and the manager had actually seen them on TV at this sporting event and was using that in a personnel file to take disciplinary proceedings, then that very much would be personal data. So often it depends on the purpose of the data. So do bear that in mind. And actually, I think a lot of people don't look into this in as much detail as they should. And that's why in really early on in my book, I think in chapter 3, there is a really full chapter on what personal data is. It's actually probably a lot more complicated than most people think. So if you're doing anything more complicated with data than having an email database, then it's certainly worth having a read of that and really educating yourself as to what's personal data. My advice is always to err on the side of caution because it's expansive definition. On the other side of the frame, a name isn't necessarily personal data if it's a common name and you only hold that data about that individual, and it's not possible for you to obtain other data about that individual. So John Smith, for example, if you just had that data and there was no other data around that name, then that wouldn't in itself be personal data. Health and biometric data comprises special category data, and as I'm sure the vast majority of you who are on this live webinar know, that special category data is subject to even greater protection. Also included in that is racial or ethnic origin data, data regarding political opinions, religious or philosophical beliefs, and data concerning sex life or sexual orientation. And the thing that a lot of people miss when you're working with cookies is that if you have a website that is in one of those areas, so maybe you've got a website that's relating to health or fitness, well-being, whatever it might be, or some kind of something to do with racial or ethnic origin, then when you're using cookies, you need to be thinking about whether those cookies are holding special category data, and then think, well, what extra steps do I need to take in order to be able to process that special category data? So do be aware of that. Oh, heck. Sorry, I've lost my PowerPoint. Right, there we go. So let's talk about some common misconceptions about personal data. Now, I get this one all the time. In fact, somebody asked it in my Facebook group not that long ago. Just because personal data is publicly available doesn't mean that the GDPR doesn't apply. So you can't just go and merrily scrape lots of websites and use that data willy-nilly. Yes, that's a technical legal term. You can't do that. You still have to have a lawful ground of processing of that data and follow all of the other requirements of the GDPR. So be aware of that. Secondly, the data does not need to be about an individual's private life in order for the GDPR to apply. It can equally apply to their professional life, for example. So again, I've had people say to me that they think that if it's about somebody in a work context, that it doesn't apply. That's not right. And a common question that I get is, if I'm sending an email to somebody at their work and it's a amanda.smith@abc.com, does that apply? And I think a lot of people get very confused around the B2B marketing and personal data and e-privacy, etc. And the actual answer to that is that if you have somebody's email address that gives their name, and obviously you also know the company that they work for, then that is likely to be personal data, so the GDPR will apply. But obviously, if you're sending unsolicited email correspondence, email direct marketing to that person, then you also need to think about the e-privacy directive. And that says that you need to have prior consent for sending unsolicited direct marketing emails to individuals, okay? However, it's not quite that simple. You might be thinking now, that means that I can send unlimited marketing emails to people within businesses. No, firstly, because under the PECR in the UK, individuals includes sole traders and partnerships. So you have to be very careful, and you'd have to split your list of people that you're wanting to email into limited companies or other corporate entities, and sole traders and partnerships. Okay, now the corporate entities you can email, the sole traders and partnerships you can't. So you need to be very careful about that. But equally, saying that, you still need to bear in mind the GDPR rules as well. And in terms of consent for GDPR, it might be possible, if you don't need consent under the privacy directive, it might be possible to rely on legitimate interests, but you'd need to do your balancing test. And if you don't know what that is, then have a look in my book. I've not got time to go into that now. Okay, so both subjective and objective data can be personal data if it identifies or is capable of identifying an individual. So if you have objective data like now what example can I give you? The basketball player is from Reigate and is 6'7" and has been in the team for 10 years. Okay, that's objective data. It's not naming the name, but if there's only one person that fulfills all of that, then it's capable of identifying somebody, and it will be personal data. Subjective data can be somebody's views about a person. So if the subjective data, like for example, maybe it's the opinion of the basketball coach who says that out of the three, that's not a regular example, so maybe it's a manager at work, out of the 3 people who applied for the role has been awarded to the only female candidate. Actually, that's objective data. So it could be the only female candidate gave a very strong performance. Okay, so that is subjective because it's the view of the manager that they gave the strong performance, but clearly it's still possible to identify that person. So that's really an issue when you're looking at personnel files and things like that. So just be aware that it can be both subjective and objective. The key thing is whether it's capable of identifying an individual. And my final common misconception at the bottom there is an exemption for purely personal or household activities. So if what you're doing with the processing is purely personal or for a household activity, the GDPR doesn't apply. However, do be careful when using that exemption. There has been a recent case of a grandmother in the Netherlands who posted photos of her grandchildren on Facebook. The parents asked her to remove them. She said no, so the parents brought a claim against her. Now, what that says about the state of their relationship, I can't comment, but the outcome of the case was that the grandmother was fined €50 a day for the amount of time that she failed to remove those photographs. And the exemption for purely personal or household activity didn't apply because she had posted it on a public platform and potentially many people could see those images which were held to be personal data. Also, going back quite a long time now, there's the case of Mrs. Lindqvist in Sweden, who I actually do feel incredibly sorry for, I have to say. She created a website as part of a computer course for church parishioners. And she included names, telephone numbers, hobbies, and jobs. And she also actually included a bit of special category data because she'd revealed that one of the people named had injured her foot and was therefore working part-time on medical grounds. And this went to court, and she was fined an equivalent of £300 for that. And it's a very famous case about this exemption. But I actually do feel very, very sorry for that church parishioner. So be careful if you are putting things online, even if you think it is a personal or household activity, then that might be bringing you within the realms of the GDPR. So do be careful about that. Okay, so we're going to take a look again, a reminder, hopefully a reminder for you. If you're new to this, then this is a good place to start for you. But the basic principles of GDPR compliance, there are 6 basic principles and an overarching principle of accountability, which really means that you need to be internally accountable. So it means that you've got the proper policies and procedures in place. It means that you're keeping records and you're doing everything as you should be doing. The first principle is lawfulness, fairness, and transparency. So you should only process personal data in accordance with the law. You shouldn't mislead individuals when you collect their data. I hope that nobody listening to this would actually want to do that. And now, obviously, there's a difference between an intention to mislead and actually innocently misleading, which I'm sure many of us do. So the real message is to be as upfront as possible with what you're going to do with people's data. And if you need to change your purpose once you've got their data, then you need to look at what you would need to do in order to use that for another purpose. It might involve getting fresh consent, it might not. So there's a chapter in my book about that. So do follow up on that. If you're wanting to use the data for a different purpose for what you told the person that you were going to use it for initially, then you need to be very careful about that. And finally, on that principle, you need to provide the mandated information about the processing. So there is a big long list of information that you need to provide to your data subjects at the point of collection of the data, and you need to provide that to them. And typically that's done in a privacy notice, and we'll look at that in a bit more detail later. The next principle is a purpose limitation, which is that you should only collect and use data for the purpose that you informed the data subject about. So again, being really clear and upfront about why you're collecting the data, and then actually only using it for that. And if you want to expand the purpose, then obviously you need to take those steps that I mentioned earlier. Data minimization, you need to identify the minimum amount of personal data necessary to achieve your purpose and only collect that data. So if you're thinking, okay, I want to build my list by putting out a free report, really you only need their name and email address in order to email them that free report. You don't need to know more than that. Now, saying that, it is possible to ask for more data. You might have 2 reports. You might have a report for a large company. You might have a report that's more suitable for a smaller company. So you can request more information if it's necessary. And again, be upfront with people and say, you know, if you would like a more targeted report, or if you'd like more targeted emails, then please provide the following data. The next principle is accuracy, which, as the name suggests, is you should ensure that the data is accurate and, where necessary, up to date. And there's probably 3 main ways to do that. Number 1, in your privacy notice, do have a statement that asks the data subject to keep you updated. And 2, you can have a privacy center, privacy dashboard, where people can go in and actually amend the details that you hold about them. And thirdly, you could email them. I think the recommendation is every 6 months. You would email them and say, here's the data that we hold about you, or you'd send a link to be able to access that data. Here's the information that we hold about you. Please let us know if it's not up to date. Now, obviously, you'd need to make sure you're sending it to the right people. You need to make sure you've got all the appropriate security in place when you do that. Or you could, if you're not that big a company, that big an organization, you could simply just email them and say, you know, please let us know if any of your data, or you could say, you know, we hold your name, your address, your email address, and your phone number. Please let us know if any of that has changed. Storage limitation: don't keep personal data for any longer than is necessary to achieve the purpose that you informed the individual about. We should all have data retention policies that list the different time periods that you'll keep different pieces of personal data for different purposes. And there is a template for that in my GDPR compliance pack. And finally, and very importantly, the principle of integrity and confidentiality. It is vital to ensure the appropriate security of personal data. This is where we're seeing the fines coming through. It's in really two areas. It's in the ad tech for not getting the appropriate informed consent, and it's in the data breach area. So certainly the security is one thing that you really need to be looking into, and that means staff training. As I said, about 80% of data breaches are caused by human error. So it means, telling them how they need to secure hard copy files. It means telling them how to password protect their devices, and really stressing the importance of it, and a lot more as well. But regular staff training for security is essential, as is obviously having those systems and procedures in place. And there is a reasonably affordable sort of check that you can get. I can't remember the name of it right now, but I think from memory it's about £250, and security professionals will come in and look at your business and will really do a gap analysis of what you've not got in place and what you should have. So that's certainly worth looking at if you haven't already. If somebody knows the name of that, you can pop that in the chat box. Okay. So what does that actually mean in practice? What are the basics for compliance? Number one, carry out a data inventory. So you need to map your data flows and record what personal data you collect, where it's stored, how it's secured, what it's used for, and where you send it. People who go and maybe copy a privacy notice from somewhere and haven't done that exercise of actually thinking about what data you hold, what you're doing with it, if there is ever a complaint or an investigation, that's probably worse than having no privacy notice at all, I would say, because it shows that you know what you probably should be doing, but haven't actually done the job of doing so. So it's really important to do this first step of carrying out a data inventory. And again, there is a template for that in my GDPR pack. And also this is useful where if you need to record your data processing going forwards, then it's good to have that, and then you'll build on it as your processing changes and grows, and as your purposes change. So that is the very first starting point. Then you need to consider your lawful ground of processing for each processing activity. So if you have a processing activity of sending out your newsletter, then you need to have a lawful ground of processing for that. And don't forget that you need to, certainly for sending out your newsletter, if it comes into the scope of unsolicited email direct marketing, you would need to also consider the e-privacy the PECR in the UK. So the lawful grounds of processing, obviously there's consent, and remember the GDPR is not all about consent. There is legitimate interests, which we know from the recitals to the GDPR can be used for marketing, but again, you have to look at the privacy directive alongside that. And if that says you need consent for your marketing, then you also need consent under the GDPR. There are contractual grounds. So for example, if somebody orders a product from your retail store and you need to have their home address in order to deliver it for them, then contract would be your lawful ground of processing. So work out what is your lawful ground of processing for each processing activity that you've identified in your data inventory. Don't forget about special category data. if you process that, and that was, remember I read out the list before, health data, ethnic origin data, etc., then you need to ensure that you fall within an exemption to the general prohibition against processing special category data. And often that means you need to obtain explicit consent. And what that means is there is a certain form of words that you need to include in your consent that sets out what the processing is, what the purpose is, and the fact that somebody is explicitly consenting in order to have that valid consent. So again, there's a very full chapter on that in my book. So if you're new to this area, then that's a really good starting point. The next step, because we're going around anti-clockwise, is prepare your privacy notice. So as I said earlier, you do need to ensure it contains the list of items mandated by the GDPR, whether that's in Article 13 or 14. And that depends whether, so Article 13 is a list of the information that is required if you're obtaining data directly from the data subject. So for instance, if they fill in a form on your website. And Article 14 is all about the data that you need to provide if you've obtained that data from another party. So do be conscious that if just because you've obtained it from someone else doesn't mean that you don't have an obligation to provide a privacy notice to the data subject. You do, and there's timing requirements as to when you do that, so make sure you check that out. And again, make sure that the privacy notice is bespoke to your business. Don't just copy somebody else's, not least it could get you sued for infringing somebody's copyright. Next on the circle there is to prepare your cookie policy. Oh, actually, sorry, before we go on to that, just in terms of the privacy notice, there's a few points here that, again, common mispractice, that's not really the right grammar, is it? Common errors that I see made in websites and privacy notices. So on your website, you will have a link to your privacy notice at all of the points where you're collecting personal data. So if you've got an opt-in form, there should be a link there. If you've got a contact form, there should be a link there. And there should be a link to it on every page of your website, and certainly one to your cookie policy on every page of your website. Just in the footer is fine. But in terms of actually where you're collecting information, it needs to be more obvious than that. So you would have it under your little opt-in box. And what I see is a big mistake is that, and so many big businesses do this as well, it really surprises me, but they have a tick box next to the link to the privacy notice, and they ask people to agree to their privacy notice. Now, what that is effectively doing is putting all of your processing on the ground of consent, which you really don't want to do, because there'll be many areas where a consent is not at all the relevant lawful ground of processing, where people really shouldn't be able to withdraw their consent, and all the other implications that come from using consent as a lawful ground of processing. So you don't ask people to agree to your privacy notice. You advise people of your privacy notice by saying something like, we collect and process your personal data in accordance with our privacy notice. Link to privacy notice. And also a common mistake that I see people make is that they say, we won't share your data with any third party. Now, don't say that, because you probably do. Okay, most organizations will be sharing data with third parties, whether that's your email service provider, whether that's cloud storage, whether it's whatever. What I think people mean to say is, we won't sell your data to anybody else so that they can spam you. Okay, so you can say it like that if you want, but just be careful with the words, we won't share your data with a third party, because you probably do. Okay, so cookie policy. You need to inform website users that you're using cookies and obtain consent for the use of any non-essential cookies before the cookie is fired. Now, what this means is, in reality, is that you're going to have some form of cookie consent mechanism on your website. And there are a variety of them. I don't think that any of them are 100% compliant. I personally use CookieBot, which is probably, if I'm ever investigated, I will probably be okay using CookieBot, I would imagine. But certainly you need to have a cookie policy that informs website users about what cookies you're using. And what we certainly know that you can't do anymore is you can't have pre-ticked boxes for people to say that they that they consent to the use of cookies. We know that under the GDPR, pre-tick boxes are not valid consent. And we know that you cannot no longer say, by continuing to browse this website, you accept cookies. So when I'm browsing and looking at, and again, very big organizations, I still see the old banner that comes up that says, by continuing to browse this website, you're accepting cookies. That's not valid. So do be aware of that and look into a suitable consent tool. And again, before the cookie is fired, many don't do that. Make sure, and to be honest, I'm not entirely convinced that Cookiebot does it entirely. We had a big discussion in my group a while ago about whether there is a suitable tool that does it all, and I think we came to the conclusion that there isn't. But certainly I know that I'm not going to get fined for using the software that's out there. If there isn't a suitable solution, then we do our best. Now, one of the questions that I had on the talk that I gave to Wordcamp was, what about analytics cookies and anonymization of analytics cookies? So you may know that if data is truly anonymized, then that is the GDPR doesn't apply to it. If it's truly anonymized, then GDPR doesn't apply. But I think I mentioned this earlier, we need to look at it alongside the ePrivacy Directive and the PECR in the UK. And what that says is that non-essential cookies require consent. And we know that analytics cookies are not essential. So even if analytics cookies are properly anonymized, you still require consent. Now, there is slight discrepancies across the EU on this. So what I'm talking about now is certainly from the UK's perspective. The ICO have confirmed this. However, as I say, there is a distinction. And what I'll do is I will post in my Facebook group this handy table of the divergence in the different regulatory authorities' approach to cookies. Certainly the French Data Protection Authority have a more relaxed approach with analytics cookies. They say that certain analytics cookies can be exempted from prior consent requirements if they meet a list of cumulative requirements provided by the French Data Protection Authority. Germany also has slightly different rules. Spain does require consent for analytics cookies. And finally, I've just seen a message saying, now there's an opportunity for you, Suzanne, making the best, most compliant cookie software. Yes, not for me, but I'll challenge anybody else to do that. And Denmark requires consent for non-essentials. Okay, thank you for that. So finally, ensure security. Do check your security practices are up to scratch. Ensure you have procedures in place for data breaches and notifications. And as I said earlier, do ensure that all your staff are properly trained. So what does this mean if you've got a website? Maybe you're a small organization, you've got a website. How do we distill this down into the things that you really need to be doing so that you keep your website users happy, so they're more likely to buy from you, they're more likely to continue to consume your content, and they're more likely to not report you to the regulatory authority? If I had to distill it down to 4 things, these would be my 4 things where I think that data subjects just get really annoyed if you don't do this the right way. So firstly, minimize the data that you really need to achieve your purpose. Minimize the data that you collect in order to achieve your purpose. I don't know about you, but when I go onto a form now, and maybe I'm accessing a free report or whatever it is, and there's a huge form of things to fill in. I'm just not going to do it anymore. They've not told me why they need that information. So I'm not yet at the point where I'm reporting them. I'm probably too busy to do that. I'm sure there are people out there who would do that. But, you know, it annoys me. It really annoys me. And if I was, you know, interested in buying something from someone, it would really put me off. So be cautious about that. As I said before, you can ask for more data, but always be upfront about why you're asking for that additional data, and give people a real choice as to whether they actually want to provide that additional data or not. And remember, you know, the more data that you're collecting, the more you've got to secure it. So, you know, it is in our interest as well to only collect the data that we really need in order to achieve our purpose. Opt-ins, this is a real gripe for me. You know, let's give real choice to our website users. Don't force users into agreeing to receive marketing emails when, you know, they don't want to. Now you might say to me, and again, when I go onto a website and I'm forced, you know, to get to, I don't know, whatever I want to get to, and I'm forced to opt into somebody's marketing list, it annoys me. And the first thing I do is unsubscribe from it. And, you know, that's kind of it, game over. Saying that, I do appreciate that when you've gone to lots, it's happened to me, I've done it before, I've gone to lots and lots of effort to create a free report for people. And of course, what I would like in return for those many hours of effort of creating a free report that I think will be very useful for people is I'd like their email address so that I can tell them about how I can help them more. Okay, that would be great. And what we can do, certainly in the UK, is we can flip it on its head a bit so that we can incentivize people to opt into our newsletter. So if you have a free report that you think might be of interest to people, you can say, sign up for my newsletter, and as a gift, I'll send you my free report. And obviously you need to be, you know, very upfront about that, very clear about that, and still give people a real choice as to whether they want to do that or not. But that's okay. Similarly with a retail offering, you can say, sign up to our newsletter and we'll give you 15% off your first purchase. That's absolutely fine. Now I know that a lot of you have probably read that you can't, what's the word? There can't be a detriment for people if they choose not to give consent. But certainly in the ICO's view in the UK, it would not be a detriment to do what I've just outlined. Now, if you said, you know, if you don't give us consent to X, then the price for your service will be 20% more or something like that. That might be a detriment. We don't know where the line is, but certainly the ICO has said it's possible to incentivize the opt-in. So again, if you're in other jurisdictions, do look into any guidance that your particular regulatory authority has put out in that regard. Cookie pop-ups, oh my goodness, a real gripe of mine at the moment. Do ensure that they offer real choice and are simple to understand and use. I've been on some websites where you have to click through to about 4 pages of nonsense before you realise that there's no way of opting out. You know, they're still on an opt-out basis, and you can't even find the opt-out. I'm never going to go near that website again. I haven't got to the stage where I'm reporting people yet because I'm too busy, but there will be people like me that go around reporting these websites. And you know, I think people who have websites might be thinking, well, you know, surely if it's simple and if it's opt-in only, who on earth is going to opt in for the use of cookies? And it's you know, this is the issue that we find ourselves in, and the ad tech industry finds themselves in this issue, because if you look at the way that the regulation is going, and certainly the amendments to the e-privacy directive, which I talked about earlier, what the EU institutions are really keen to do is end this under the radar surveillance that goes on all the time, the vast majority of people don't know about. And it's estimated that 615 million people already block cookies. So this is, you know, this is an ongoing issue. And what I personally feel that advertisers should be looking to do is to look at new models of advertising, to look at contextual advertising rather than behavioural advertising, which is ad placement done smartly. So if I'm browsing on a golf website because I want to improve my swing, I'm not, by the way, because I haven't played golf in about 10 years since I had my children, but before that I might have done. On that website page will be an ad for some golf shoes, for example. So the ads are relevant to the topic of the website rather than this, you know, this big data stack that's being gathered by the ad tech world on me and my likes and my preferences and my browsing behavior and all of that. I would much rather personally have that myself. So I think we're going to see this shift longer term from this, you know, this under the radar surveillance. And actually, if you are interested in it and you want to know more about the way that the changes to the privacy regulation directive is going to affect cookies, then what they're looking at doing is making consent for cookies at a browser level, which means that rather than all the pop-ups, when you install a new browser or whatever, there will be an option to accept cookies or not, and the default will be off. So it's going to have a massive impact on the use of cookies and the ad tech industry, and that's why the advertising industry have lobbied so hard against these proposed regulations. So cookies, ad tech, consent, it's a very interesting area. And as I say, I think that we're going to see huge shifts going forwards in the way that advertising is done. And then finally, keep it to yourself. Don't share the data with third parties without being totally upfront about it. Now, there will be some third parties you can share data with without consent, but for those third parties, maybe where they are going to market to the data subject, then you will need consent. And you'll need specific consent for those parties. We know that it is not sufficient to say, tick here if you're happy to receive offers from carefully selected parties or partners. That's not specific enough. You would need to list each entity, each organisation that you're wanting to share the personal data with, to the extent that that third party requires consent in order to process the data, as it would do if it was sending unsolicited marketing, for example. Okay, so, gosh, time does go on. Maybe I just talk in a very slow, long-winded way. But anyway, I just get very excited about it. So let's quickly talk about some danger zones for those website publishers in the ad tech stack. So if you have a website and you're using adverts on your site and you're dealing with intermediaries, so ad exchanges, DMPs or DSPs, then it's really important to check their contracts and work out whether they're a data controller or a data processor, because obviously your respective obligations will very much depend on the role that you both take. So that's number one, to check. Number two, do check that your partners in the advertising world are GDPR compliant. Check the contract that they have with you, but also carry out wider due diligence. You know, the big ones will have a page that covers this, but you need to know what they need to be doing to be GDPR compliant and actually check that they are. Do beware real-time bidding. If you're using that, it's being challenged as not being compliant with the GDPR, even if you're using the various frameworks that are out there for that. They are being challenged as not compliant, so be very careful about that. And finally, in terms of the sort of using intermediaries for advertising context, do be wary about the right to be forgotten, because when data subjects exercise that right, you need to delete certain data from not just from your own systems, but also from your partner systems, and that can often be very difficult. So if you are in the ad tech stack, this is something that you need to take really seriously. We know that this is an area that all of the European regulators are focusing on. So if you are involved in this area, then certainly you need to spend more time looking at how you're compliant and how your partners are compliant. Now, I've got a piece on it in the marketing section of my book, but if you are doing this on an ongoing and a fairly large scale way, then I would actually recommend that you speak to a data protection professional or lawyer. So, marketing hot zones. I'm going to have to rush through this because I don't want to have time for questions. We don't want you to get burned in your marketing. We want you to have compliant marketing, not lots of complaints about your marketing. So I'm just going to highlight 3 of the main risk areas here. Firstly, as I said earlier, B2B, there is often a distinction between B2B and B2C marketing. But that doesn't come from the GDPR, which is a common misconception. That comes from the e-privacy directive. And as I said, each EU member state and the UK now, each has interpreted the e-privacy directive slightly differently. So you do need to check the rules on that on a per country basis if you're marketing into those jurisdictions. Often B2B is more relaxed, but that doesn't mean that there are no rules around B2B marketing. So do make sure you know exactly what the position is there. Legitimate interests. Now, a lot of people still, after 2 years in the marketing world, still think that you can just say, oh, we don't need consent, we'll rely on legitimate interests. It says here in the recitals that marketing, you can use legitimate interests for the purposes of your marketing. Yes, it does say that, but don't forget that you've got to read it alongside the e-privacy directive. So certainly for any online marketing, you need to be very careful about that. Now, saying that, if you're doing old school postal marketing, then again, do look at the on a jurisdiction by jurisdiction basis. But certainly in the UK, you're doing postal marketing, then yes, you're probably okay relying on legitimate interest for that. Saying that, you have to have carried out a legitimate interest assessment form where you do the balancing test that basically weighs up your legitimate interest to market and grow your business against the data subject's rights and freedoms. Now, obviously, if you're sending them post through the door, there's a little place they can phone or write to opt out, then you're not really affecting their rights and freedoms. But certainly if you're dealing with special category data, if you're bombarding them with emails or sending them nuisance calls on automated calling, that's a totally different matter. And as I said, for the automated and online marketing, you really need to look at the e-privacy directive as well. But if there is an investigation, then and you've said that you've relied on legitimate interest, then according to the accountability principle, the relevant authority will be expecting you to have a legitimate interest assessment form completed and on file that shows that, on balance, that you've really thought about the rights and freedoms of your data subjects and that your legitimate interests outweighs that. So be really careful. Don't just fall into the trap of thinking, oh, we can just rely on legitimate interests. It's not the case. And finally, on that row, do remember about preference lists. Some EU countries have marketing preference lists. Again, it varies from European state to state, but do screen those lists in advance of sending marketing. Those people on those lists are probably on there because they care about this kind of thing. And so aside from any regulatory sanction, they are, regulatory sanction in terms of, if you were if there happened to be an audit, and somehow they found out that you hadn't taken that into account, that would be one thing. But really, how you're going to come to the attention of a regulatory authority is someone's going to complain. And the people on those preference lists are the people who really care about data protection. So don't piss them off by sending unsolicited marketing to the people who've opted out. So do bear that in mind. So at the bottom there, you can see the online and offline marketing. Do be very conscious that there are different rules for each of those forms of marketing. Again, in my book, I've got a really full chapter on marketing with pretty much every type of marketing that I could think of and the practical implementation of it within your business. So that's a really good starting point if you haven't already got all of this scoped out and mapped out. One thing I do just want to say about Facebook marketing, it's a fairly new case. Facebook marketing and custom audiences and uploading personal data to create custom audiences into Facebook. The Bavarian DPA in Germany said that explicit consent is required. So what that would mean is that when you're collecting that data, there would need to be a tick box with the appropriate statement that says, I'm okay with you uploading my data for the purposes of Facebook audiences. Now you might say, who on earth would tick that box? I don't know. Sometimes I actually prefer to have targeted Facebook ads than total random Facebook ads, but there you go. Maybe not many people would tick that box. However, there is a distinction we can draw, because that was a case that was related to special category data. So we're not entirely sure if that wouldn't apply if there was no chance of special category data being used in that. But just beware, because certainly in my book, I make a strong case that legitimate interest could be used for uploading data into Facebook. So just be aware that there is that case, and I think that will evolve. So keep an eye on that area. And of course, if you have people on an email list and you're using that for custom audiences, then do make sure that you're updating your custom audiences so that when people opt out of your email list, they're also opted out of your Facebook ads custom audiences. Okay. Right. So finally, on Brexit, 31st of December 2020, I just wanted to touch on this very briefly. I have done more trainings purely on this issue of Brexit. So if you are a member of my Small Business Legal Academy, then you can access all of those trainings and the hundreds of others that I've done on not just data protection matters, but on all things legal to do with your business. But the recordings are in there. I'm sure I will do another live one nearer to the 31st of December when we know where we are with adequacy. But these are three things that right now should be on your radar. So the first thing is for international transfers. We are still waiting to see whether the UK will be granted adequacy status. And what that means is that if the EU thinks that we have adequate protection for personal data, then there won't need to be any further safeguards for international transfers, because the UK won't be part of the EU. So an international transfer would be any transfer of personal data from within the EU to anywhere outside, which will include the UK after the 31st of December. So if it's granted adequacy, happy days. If it's not, then transfers from the EU to the UK will require additional protections. So what you need to start doing is identifying any of those transfers and start conversations with your vendors and partners, etc., and about the possibility of having to put those extra protections in place, like standard contractual clauses. And just obviously know that this is an issue and keep an eye on the progression of adequacy status discussions. We all hope that we won't have to put extra measures in place, but it will very much depend on how those discussions go. The other thing to be mindful of is that we will no longer, certainly if we're in the UK and we only are established in the UK, then we will no longer have access to the one-stop shop. What that said was that if you have data processing that affects data subjects in lots of different EU jurisdictions, if there's a data breach or a complaint or whatever, then rather than having to deal with each regulator in each affected jurisdiction, then there would be a lead supervisory authority and you would only need to deal with the lead supervisory authority. Unfortunately, after Brexit, we are no longer going to be party to that one-stop shop. So as I say, if you're solely established in the UK, but you have you have data subjects in lots of different countries within the EU, then you face the prospect of having to deal with a multitude of EU regulators. So bear that in mind. You might want to look at, identify where your data subjects are and start looking at the regulators approach, and be ready for that. And finally, the issue of representatives. If you process the personal data of people in the EU, but you don't have an establishment in the EU, you will need to appoint a representative based in the EU. And that is the same for organisations who are established in the EU without a presence in the UK. Then you will need to appoint a representative in the UK. So again, there's a chapter on that in my book. If you think that might apply to you, then that's something that, again, you need to be mindful of. You might be wanting to look at your options in terms of who you can appoint. Law firms offer the service. There are sort of standalone representative consultancy services now. But I did a webinar with one based in Ireland, who I'm very happy to provide the details of nearer the time. But you have to, I mean, a lot of people might want to choose Ireland for language purposes, but if you don't actually have any data subjects in Ireland, then you can't use an Irish representative. You have to choose a representative in a jurisdiction where you have data subjects. So just be mindful of that. So those are the three things. There's a number of other minor, well, other issues that we need to be aware of, but they're probably my top three that you need to be, sort of thinking about now, bearing in mind and keeping an eye on to see, well, certainly the first issue there, you need to be keeping an eye on that. Okay, so last slide before we get to some questions. So why understanding privacy and cookie laws is critical for your business success? Well, trust. We're seeing, it's becoming so much of an issue these days, is that if people feel that they can't trust you with their data, then A, they're not going to give you their data, and B, they're not going to do business with you. And on the flip side, increased trust, it means you're going to get more customers and more spondoolies, which at the end of the day is what in business we all want. So trust is becoming more and more of an issue. And it's a real concern for people, as you saw from that initial slide. It's 82% of people in the States very, very concerned about data, the issue of online privacy, going down to 65% in the Netherlands. Everybody is very concerned about it. And I really feel that businesses can be market leaders in this area. You can use it as a selling point that you care about your data subjects privacy. And indeed, I've probably become the best customer of a certain organisation where they've really done this very well. So, this is something to consider. Avoid brand damage. Really, I mean, gosh, if we are unlucky enough to, or negligent enough to suffer a data breach, and that's then publicised, that's going to cause us real brand damage. We know how hard it is to build a brand, and we know how hard it is to repair a brand once it has been damaged. So we really don't want to risk that. We want to avoid complaints. Individuals are savvier about their rights, more so than ever, and they will complain to either us or the regulator. We don't want to risk a pissed off customer bad-mouthing us or an investigation from a regulatory authority. We can save time, less time having to deal with complaints, data breaches, data protection rights, repairing brand damage. You might have to put a bit of effort in up front to put all of your policies, procedures, staff training, security, etc. in place. But I bet in the long run, that is going to be more time economical for you. You can avoid fines. I mean, even though you might not be fined 20 million, I think you'd have to be doing something pretty dodgy. That's a technical legal term, to be fined anything like 20 million. But any level of fine is a chunk of cash out of your pocket that you just, I still think back to that poor chap. He had a really small business and he sent one email to the wrong person that contained personal data and was fined £1,000 and is on the list, the publicised list of the named and shamed people who've not complied. And I use him as case studies in my materials. I mean, the poor chap very innocently did that, but that's, we don't want to have to deal with that as small business owners. We want to avoid civil claims. Yes, there are ambulance chasing lawyers out there who are advertising to individuals who have suffered data breaches for them to bring claims. We don't want to be on the receiving end of that. And finally, I don't know about you, but I want to feel good that I'm treating people's personal data in the way in which I would want my personal data to be treated. So ladies and gentlemen, that is why understanding privacy and cookie laws is now more than ever critical for the success of your business.